couple of days. Well, when the matter started, it was a completely foggy situations. In a sense, nobody knew
What is going to happen?
exactly how much percentage of freshers will be getting it. Now today, fortunately, I am in a position there is enough sunlight.
Good.
The result of the sunlight is
But I think Mr. Dhar will take today. Can I come back on other day?
I have concluded only few
Yes.
things were left out, so I will not take much time.
Oh. But the State Advocate
There
General will
are
have.
others. There are others. There are others.
There are others. There are others are
Just
there.
what
But,
is that there?
but can I come back on the next day?
All right.
With your lordship's leave, I am leaving.
Yes.
Lots of
What is the sunlight?
yes, sunlight. Okay, just
Yes.
hello, there is before Lordship look at it.
And this data is collected from the website of the
Yes, yes,
commission.
yes, they have got it, and it can be verified. If I am wrong, I don't think.
No, but then this is from the commission's website.
I believe.
Where from did the figures come?
Huh? Well, because they are not allowed. Can one person be allowed? Can one person become? কেউ একজন আসুন আপনি একজন এখানে আসুন
Did you not inquire where from these figures
these
came?
all times whatever figures they have given
Huh.
it was found to be absolutely right, but I really do not know. Must have been but like vacancy positions,
But
how
that is
numbers.
disclosed.
Yes. Website থেকে data নেওয়া হয়েছে, huh? But this is right websites. My lord, I termed it before I when I show this. The entire argument had been that there is a possibility of prejudice, my lord, which is definitely a very good argument. Now, any very good argument can become or may lose that goodness of that argument if the fact remains completely different. Now, this fact is this. In class 9 and 10, the total number of candidates called, this calling is 1.6 is to 1, 39,207. Out of that, freshers represented, my lord, 27,000 and odd, which is 68.89%. So basically they are beaten. And the in-service were 31.11%. That's I'm saying in 9-10. 11-12, my lord, if I go by percentage, because percentage gives us a, my lord, clarity. The freshers are 49.4 and in service we are 50.so. So in 11-12, we are little better in that sense. And overall, if Lordship look at that, overall freshers in the entire these competitions, they are 62.25%. They have been called. And we are representing 37.75%. My lord, here the logic as my respectful submission before your lordship. Now, first 1 and 2, this is just the figures. 3, overall freshers constitute 62.25 of all candidates called 37,000 out of 59,447. Now, if experience marks were prejudicial in service candidates, would dominate. The actual data shows the exact opposite. Now, written examination, that I began with not because I didn't have the data on that day, but I was trying to, my lord, persuade your lordship that 60 marks, that's the dominating factor. Now, factually is found to be possibly, my lord, that I was right. Written examination 60 marks remains decisive. Freshers who performed well easily overcame the 10-mark experience advantage. The contention that the freshers are prejudiced is not supported by facts. So 25 rules. Therefore, my lord, this is my submissions. This is a fair, balanced, and constitutional. So if I can just say one sentence more on this, that I am only trying to delink all other submissions based on a hypothesis. It can stand for any other factual scenario. But in this factual scenario where skill was given some weightage, in reality, it has not done that kind of bottleneck situations that they are not able to compete. So this is my respectful submissions. So even if there is an excellent argument, there is an excellent judgment which is contrary, but factual position shows that there are, if I can use this term, more intelligent, more meritorious freshers. They have come, and this is the percentage which I have done, my lord. My lord, only few things are left over. It daw first. 10 pages. Exclusion. Oh, that will come later. 10 first. Got it, no? Got it. Well, this is a direct judgment 2000. 2014 6 SSC 644 Joginder Pal, paragraph 23. This defines, in fact, I have brought the Blacks and also Oxford. I found that inspiration was got from this both, and that the Honorable Supreme Court have found this. Paragraph 23. What is the meaning of the word tainted? Uh, 23. In this backdrop, the High Court rightly covered these persons as tainted persons, ascribing following meaning to the expression taint. Now, this is the meaning. The word taint, as per the new shorter Oxford English Dictionary, can be expressed to mean a trace, stain, or a blemish. It denotes some evil quality, a contaminating or corrupting influence. It can lead to mean and imbue with anything objectionable or to contaminate or infect. The word taint, when used as a verb, means dishonest, destroy integrity, vitiate, tarnish, and degenerate morally. Well, why? So, one word, if Lordship look at the components, these are the different, I would say, somewhat synonymous kinds of words. Unless and until I have been specifically found to be dishonest, it's not a simplicity of violation of anything. Possibly the Honorable Supreme Court, my lord, has would not use the word taint. So therefore, all these words, dishonest, destroy integrity, vitiate, tarnish, and degenerate morally, all in one term, that's, I have to be corrupt enough. There has to be some contributions. There has to be something which shows that it's not a mere violations. I have lost the integrity. I am dishonest. And since, well, this is the, if Lordship kindly take the Black's Law Dictionary on, this is 10th edition. I have taken the first page, edition page, and the relevant page, 10th. Page number 1681. Taint, to imbue with a noxious quality or principle. 2, to contaminate or corrupt. 3, to tinge or affect for the worse. Originally, to taint was to affect only slightly. Today, however, to taint is normally to affect seriously for the worse. So maybe one day, once upon a time, taint was a little bit, but now the dictionary shows the historically it has to be something. And
Serious.
yes,
It
madam.
has to be something serious.
Serious. My lord, because that's the reason, my lord, the loss of integrity, the dishonesty. If I can use, my lord, in a very simple terms, some contributions on my part in the corruption. Just because, if Lordship kindly, my lord, I was also thinking in this way. Well, if there is a selection process, I'm a part of the selection process because I am one of the candidates. If the selection process corruption happens, then corruption happens because of involvement of some persons, maybe persons from the side of the authorities and the persons from the side of the who have got the job. In both cases, ultimately they create, my lord, all these things based on the components. So leaving aside the authority part, there has to be involvement as far as I am concerned. If I am a candidate, that I have lost my integrity. It is not enough that I have participated in a selection process which lost integrity. That's not enough to call me as a taint. I can be called to be a taint if I have lost the integrity, if I have become dishonest, which, my lord, so the Honorable Supreme Court have mentioned that specifically. It's not just a violation. The rule prescribes within such time something has to be done. So authorities have done beyond that. It is not just that. There has to be something more than that. No, but well, there was one point but in one of the writ petitions was taken. Well, may I also, because after the last day, whatever happened, there are two orders by the Honorable Supreme Court. Like earlier situations, there had to be, everything had to be done by 31st. But now this has been extended up to 31. It might not have been brought to the notice of your lordship. May I just hand over that also? This does not touch with the merit of the matter, but just to say that if lordship kindly take this order dated 18th December, this miscellaneous applications are ordered granting extension of time for completion of the selection process concerning assistant teachers for 9 and 10 on the one hand and for 11-12 on the other till 31/8/26 or in the event the process is completed prior to that date. So sealing is now August. Till the said date, whichever is earlier, completion of the selection process would mean culmination in issuance of appointment orders. But thereafter, we make it clear that the untainted teachers already appointed who were permitted, the orders I already placed before your lordships, to continue up to 31/12/25 shall continue to hold their post till such date of completions of the process. I am representing those untainted teachers. So now we can continue up to that. Well, on the very same day, another order was also passed. Lordship may kindly remember in one of the non-teaching matter, relying on a teaching matter of Orunima. Orunima was a teaching matter. Lordships, in an interim measure, also allowed that, in a contingent way, allowed the concessions, age relaxations for those non-teaching sector. While Lordship passed that order, Lordship relied on Orunima judgment. Now, School Service Commission, my lord, they took it up before the Honorable Supreme Court. There one point that I think this is my duty to my lord. Huh? Correct. This is. I must clarify one thing, that this matter, my lord, did not arise from the teaching matters. It arose from the non-teaching. But the reason I am showing it, that Lordship's interim order was relying on the Orunima. So effectively principal. So there, my lord, if I can just place it. Having heard the learned senior counsel appearing for the petitioner commission, the senior counsel appearing for the state of West Bengal, and the learned senior counsel appearing on caveat advance notice such and such for the writ petitioners before the High Court. We are of the opinion that it would be appropriate for the High Court, which is still seized of the matter, to hear the parties concerned on all aspects after inviting necessary counter affidavits and rejoinders thereto, if any. Without undertaking this inclusive exercise, it would not be proper for the High Court to pass an interim order summarily that would have far-reaching consequences. We accordingly direct the interim order passed by the High Court on such and such date to be kept in abeyance till the matter is heard fully by the High Court and a final order is passed, be it in the interlocutory applications or the writ petition itself. The High Court would be at liberty to fix time frames for completion of pleadings and proceed in the matter thereafter. My only purpose of placing this before your lordship is this, that though I do acknowledge that this is not an order directly from the teaching matter, but taking the principle, and since all the matters were taken up by the Honorable Supreme Court and your lordships also relied on either way for the principal purpose, possibly what the Honorable Supreme Court indicated that these matters have to be decided finally. Because lordship may kindly remember that since we were getting our salary, because the Honorable Supreme Court somehow, my lords, unlike the non-teaching, took care of our survival. Now, in various matters, my lord, some interim order was sought for variety of interpretations, not only on one ground. For an example, one ground was that this is not in this matter, in some other matters, that if someone is appointed based on paragraph 31 of the Honorable Supreme Court, then it is after expiry of the panel, then he is also untainted. So my respectful submission before your lordship is this, that we are continuing on the basis of the Honorable Supreme Court's order based on untainted. They are to continue up to 31st December. Thereafter, taken note of, still we can continue up to that. I am not at all saying that lordships would not decide who is tainted or who is not untainted. All I am praying is that possibly, if lordship feels so, that lordship would decide that part in a finality. Because in the midst of that, like I was trying to understand this way, in the midst of that, kindly visualize that we are getting the salary, we are putting our service. Two interpretations are there. Now, one interpretation which petitioners think that that is the correct interpretation is that regardless of what is the tainted list.
No, it will be decided finally
Finally.
by interim order.
Yes,
It's all right.
Yes, because well, the only, if I can just say only one sentence, because our only fear was this, there are a number of matters. Like we are protected, for an example, there are 10 matters. But in one matter, one judgment, but that can also have a serious affectations. But I don't need to say that. All I say that either way, lordship will decide, it should be finality of it. But as far as the whether panel expiry, after expiry of the panel, they should be tainted or not. Though I made some submissions on the other day, but essentially there is a separate matter for this purpose. Lordship may kindly remember that there was one order initially lordship passed, thereafter lordships did not pass that order. So I'm not making my entire submissions on that. I will
Reserve it for that
yes,
other
yes,
matter.
for that matter. Because this matter, my lord, I want to put a barrier in a sense that, take it as my submissions, that challenging of the rules, 10 marks, weightage part, my entire endeavor before your lordship is that this is constitutionally valid
Alright.
and this is proper. And today there is no fog. There is a sunlight and it clearly shows that there is a fair chance. But that chance was for the more intelligent, more meritorious persons.
All right.
Well, this would be my last submission. One intra point was taken, like those who had the experiences 9-10. Now, whether they
That
would
experience can be counted for
11, 12. So that's so. So if lordship take it from a legal perspective, rule requires an experience in secondary level. whether the secondary level includes 11-12 or not. Some submissions were made that it is not. So to respond, I will just show two things. Number one is the very definition, though. Copy that. Now, kindly take the West Bengal Board of Secondary Education Act 1963. Lordship may kindly come the third page, the definition of secondary education. F. देखो. And the second, Lordship has got. By saying third, I have not, this is actually in SSC online, it is page number 5. But from physical,
Yes,
that-
page number 5.
yes.
L, secondary education.
Sorry, it is L.
Right.
Sorry.
Hmm.
So that is, I just saw it as F. Secondary education means general education above the primary education stage, provided for students with a view to qualifying them for admission to a certificate, kindly this is, to a certificate, diploma or degree course instituted by a university or by government or by a statutory body, and include subject to any general or special order of the state government. One, technical education, agriculture education, commercial education, education for the physically handicapped, education for the mentally retarded and defective, education in reformatory schools and jails, or 7, any other types of education which the state government may in consultation with the board. So my respectful submission is on the word above. So anything above primary which takes them to diploma, university level and all others, that comes under secondary. So it is a wider variety. And the same, my lord, that is in absolutely in sync with the national education policy. That also says so. Lordship may kindly take the National Education Policy 2020 at page 11. National Education Policy 2020, relevant paragraph is 4.1.
Yes.
Well, I shall be mainly relying on the last two sentences, but it's a short paragraph. I'm reading entirety. 4.1, the curricular and pedagogical structure of school education will be reconfigured to make it responsive and relevant to the development needs and interest of learners at different stages of their development, corresponding to the age ranges 3 to 8, 8 to 11, 11 to 14, and 14 to 18 years. 14 to 18 years covers respectively. The curricular and pedagogical structure and the curricular framework for school education will therefore be guided by a 5+3+3+4 design, consisting of the foundational stage in two parts, that is 3 years of Anganwadi preschool plus 2 years in primary school in grades 1 to 2, both together covering ages 3 to 8. Preparatory stage, grades 3 to 5 covering age 8 to 11. Middle stage, grades 6 to 8 covering ages 11 to 14. And secondary stage, grades 9 to 12 in two phases, that is 9 to 10 and in the first, and 11 and 12 in the second, covering ages 14 to 18. So my respectful submission is that this, referring to the secondary experience, possibly the rule maker never wanted a mathematical precisions of a particular subject taught in the 11-12. All they wanted that they should not have the experience of the primary, they should have the experience of the secondary, meaning thereby above what is there in the statute itself. So that's the reason. And if your lordships look at the leaving aside the law point also, if lordship look at from otherwise, that any experience teaching experience, unless there is so sharply different. For an example, someone is teaching, if I can say, mathematics. He may not have any experience in maybe completely a different subject. But overall, if a question comes whether he has a teaching experience in a secondary or not, and whether for which he would get the benefit, my respectful submission would be, my lord, the rule as a matter of policy, having chosen not to make a differentiation, taking a clue from the 63 Act itself, the definition of the secondary educations, which is also in sync with this education's policy, which is up to 14 to 18 years, it is valid and it is not violative of any of the constitutional provisions. Well, these are my responses. I only seek leave at the end, my lord. I shall give a short reply.
Can reply by the applicant, by the added respondents.
Yeah, no, I missed it. What your lordships?
Reply by the respondents. Reply by the respondents.
By
Will
my
it be done?
submissions.
No, you said at the end you'll make further submission.
No, not submissions. I said at the end, when
Yes.
the entirety concluded,
Written note.
lordship allows me, I can give a very short 2-3 pages note.
Note.
It's done.
All right.
I don't want anything else. What is something?
Is 2016 we were in to that.
Which matter?
33 Bhim Sarkar edition of added respondents.
Okay. Well, there is only one, though I am representing all, but there are some who stand even a better footing. Well, there is one paragraph in the main judgment of the Honorable Supreme Court that who had an earlier service. Like there is one applications wherein some persons he had an earlier service. So that's an application in the item 33. Item number 33. ওটা কি allow হয়ে গেছে?
Can 7.
That has also been allowed.
Yes, can 7.
So only they seek that if because this point because they were apprehensive because of that definitions of the tent, because of the several.
Then those who were
So
in
now that
earlier
is-
service, they have been permitted to be repatriated.
Well, they should be permitted. They should be permitted.
So that is a different thing.
No.
Are they again participating in second SLSC?
Well, many of them are also participating. Many of them
Alright.
also participating. But they are parties because they are only apprehensions at that. Because today I don't think there is any apprehensions in courts of hearing.
Yes.
It can only be whatever the judgment will come.
After the judgment.
Yes, because they were
What
apprehensive.
are they apprehending?
Their apprehension was that as an interim measure, if Lordship decides that anyone in 16 appointed after third counseling, they are also be treated as a
Tainted candidate.
then what will happen? Neither they would be able to go back. It will. So that's the reason.
So this is a risk which these teachers are taking. You never know what the judgment will be.
Correct.
Right? And they are already recommended.
Yes.
I do not know.
But they
but
can
then
go back. May I?
can
Because,
go back.
yeah, they can go back. Yes. May I? Because this matter will continue. May I take specific instructions?
So take instruction, no issues with that.
And then I will accordingly. I will.
Yes.
Well, these are my respectful submissions. Deeply obliged.
Yes, who would like to argue next?
Well, item 33. Well, I am the added respondent in can 6, my lord. Can 6, item 33. Enter bar করে দিন।
What is your status?
Well, we are the untainted teachers still continuing in the service pursuant to the order of the Honorable Supreme Court. 20
Correct.
teachers have
20.
come before your lordship.
Untainted means what?
2016 appointed
Huh?
untainted teachers.
What does untainted over here mean?
Well, here, my lord, according to the Honorable Supreme Court order, we are continuing our job. till
That
our-
is different.
different.
What untainted in the sense you were neither found to be rank jumped, you were not in the list, and you were not even appointed after expiry of the panel.
No,
No.
third counseling.
Third counseling was done after the expiry of the panel.
Well, that is, my lord, another matter is pending, my lord. That is another thing, my lord. After whether they our fault or there are some reason, my lord, for that reason, my lord, the delay was
No,
done for
that
the
argument has been elaborately made that the
that
candidates
matter
who
not
have
today,
been
my lord. That
is
matter.
continuing.
Mostly,
Candidates who were appointed beyond the cutoff date of the panel, expiry of the panel, they should not be taken to be as specifically tainted candidates. This is the argument that is going on. Which category do you fall?
My lord, that 20 teachers are, my lord, are continuing their job pursuant to the order of the Honorable Supreme Court.
Listen, try to understand.
Yes, I understand, my lord.
What do you
That is,
understand?
my lord, disputed question of fact that matter is already pending before your lordship, whether we are within the zone of untainted or not.
Right.
That is another matter, my lord. But here, my lord, item 33, probably, my lord, that question or that after expiry of the panel, those candidates, those teachers have appointed, whether they are untainted or not, that is consideration before your lordship in another matter, my lord.
Yes.
But here, that 20 teachers have come before your lordship, my lord. We file, my lord, affidavit in opposition. Kindly have a look into my affidavit in opposition.
What is your stand, you tell?
My lord, my stand already now, my lord, from my learned senior friend, I came to learn that already freshers in respect of 9-10, 68.89%. And my lord, 11-12, 49.4%. So, my lord, those teachers, untainted teachers appointed in the 2016, they already left the field. Most, my lord, according to my lord, information, 1,500 teachers.
Left the field, what does
They
this
left,
mean?
my lord, in the competition. In the competition. And
They were not successful.
no, not. Because of the 2025 rules. Because of the new rules along with fresher candidate.
Hmm.
My lord, the ambit of the judgment of the 3rd April passed by the Honorable Supreme Court in paragraph 49, nowhere it is stated that SSC, West Bengal Secondary Board, SSC will frame the rule and we have to compete with the fresher candidate.
So you are also challenging the rule.
No, my lord, here we have addition of party, my lord. My lord, my lord, contention before your lordship that due to this rule, we are affected.
That means you are challenging the rule.
But in the addition of party, we cannot challenge that rule. But our contention before your lordship that the on 3rd April 2025 order and 26 November 2025 order. Kindly have a look into 26 November 2025
Listen,
order.
try to make
But
things
our
clear.
interests have been affected.
So you file a fresh writ petition. Why do you add
that
yourself?
petition is pending before your lordship and that is fixed on 12.
Are you a party over there also?
They are also, the writ petition are filed, some of the writ petition are filed, but that writ petition challenging the 2025 rule, they are the untainted teachers. That was admitted by your lordship and directed for opposition.
Here, the applicants whom you are representing, did they file any application in that matter where the tainted list has been challenged?
Malab, 2025 rules challenged by other untainted teacher, not
You-
these petitioners.
Not you.
No, my lord.
So what grievance do you have over here?
Here, my lord, the applicant's contention before your lordship, first 3rd April 2025, 2025 order. There, my lord, here post has been decreased. Some other post has been vanished, my lord.
Sir, you are getting it wrong. The petitioner is challenging the rule. You are also challenging the rule. Right? Why don't you come up with a fresh petition?
Well, that petition is pending.
By some other party.
Some other person.
Very well, whatever will happen will cover you.
But here, my lord, kindly have a look into kindly have a look into my petition, my lord.
What is
Addition
your
of party.
grievance? Your grievance is challenging the rule.
My lord, challenging the rule or 10 months experience.
That
10
is
months
all in
experience.
the rule.
We are not, my lord, we are not benefited.
That means you are challenging it.
The challenging
Things
that is
clear.
true, but 10 marks, my lord, additional marks not benefited us. My lord, now it is clear and crystal that marks not benefited us. That 10 marks experience not benefited us.
So
We
you are
already
not
left out.
sure whether you challenge the rule or you do not challenge. You participate. You are entitled to the 10 marks. Even then you fail to qualify and now you change your stance.
Because, my lord, I am not changing our stance, my lord. Because of the fact, my lord, along with fresher candidate, we did not compete. Because of the but that is not the contention of the Honorable Supreme Court on 3rd April.
File a fresh composite petition and let us see or wait for what happens to the other petition where the matter is pending. You do not have any grievance over here.
My lord, kindly have a look into my petition. 1 second, my lord.
You say whatever is there.
My lord, here the 20 candidates have got the marks, my lord, in the written examination. My lord, page 11, Roman 10, my lord. Page 11, my lord, out of 60, 47, out of 45, 40, 48, they got the written examination. Got the marks in the written examination. In spite of that, my lord, now, my lord, they left the field because of the, my lord, the marks awarded for only postgraduate and graduate level, not for, my lord, Madhyamik examination, higher secondary examination.
Sir,
And not only that,
come up with a fresh petition with all your allegations and whatever grievances you have. In the
and
petitioner's
regarding, my lord,
petition,
2611, kindly come to 1 second, my lord, 2611 order, my lord. Your lordship, kindly, one line. My lord, High Court shall also be mindful of the fact that the untainted candidates in the past election were allowed to sit. I am not on that, and their candidature cannot be adversely affected by application of the new rule. Our candidature already been affected
This-
because of
listen.
because of the new rule.
try to
Already some
understand
post-
one thing.
My
This
lord.
is not an open forum where you can go on making submissions. There is a petition before the court. Either you say yes or you say no. If you have something else to say, come up with fresh petitions. Here, you cannot. What is the can? Can number 6.
Can,
Please come. Take one order, please.
can 6.
In item 33,
I think, my lord, yes, Bhim Kumar Sarkar.
Bhim Kumar Shah, please come. And order record করুন তো. Can has been allowed. Can has been allowed earlier.
Earlier allowed.
Right? Take down item number 33, 24899 2025. The applicants in Can 6 of 2025, 6 of 2025 in connection with 24899/2025. Challenges the act of the commission Commission and the state respondents in publishing and framing a new rule for conducting the examination for recruitment of assistant teachers. Stop. It has been submitted that the same is contrary to the judgment passed by the Honorable Supreme Court on 3rd April 2025 in the matter of Boishaki Bhattacharya cost title লিখে দেবেন ঠিক আছে
26,
paragraph
2611.
the application of the petitioner for addition of party was initially allowed, but after hearing the applicants, it appears that
Every novel.
the cause of action which the applicants are espousing cannot be decided in the instant writ petition at the instance of the applicants. Stop. It will be open for the applicants to file fresh writ petition challenging the action of the authorities if so advised. Stop. Can accordingly stands dismissed.
Obliged to your lords.
In
কেন কেন
cannot treated to be days list করে কত আরে ওটা তো অ্যালাউ হয়ে গিয়েছিল
কেনটা তো আগে
Yes, next submission by
Item 37, my lord, for Can 4, your lordship had already added us. My lord, we have filed an affidavit in opposition. Last occasion, it has been recorded also, my lord. My lord, this is that matter, my lord, where the petitioners says that candidates of 9-10 will not get the marks of teaching experience since they have.
please make submissions. Because just now this point has been addressed.
Yes.
Make submission.
My lord, only one thing, my lord. We have filed an opposition. That's why I have stated, my lord. My lord, Mr. Sharnal is leading me. My lord, he's coming. My lord, just 10 minutes. Can it be passed over for 10 minutes only?
All right. Anybody else who wants to make submission? Applicants?
Item number 32,
Yes.
Can 5, I'm one of the
Right.
applicants. I'm being led by Anuruddha Chatterjee in this matter. He's on his legs, man. He's on his legs.
Somebody should be here. See, the senior can always be on his legs, but somebody should be there to at least carry the matter forward and so that the senior steps in.
Just
Not there. Item 32, there were many applications, if I can remember correctly.
I'm from Can 5.
And 5, there means there were 1, 2,
Three,
and then
four.
3, 4, and then 6 also. Anybody for the applicants in these matters? Because prior to starting with the state and the commission, I would like to finish off with y'all. Why don't you start so that Mr. Sanyal can come and take it up?
Vishwajit Vishwast.
In which matter?
Well, item 37.
57. Vishwajit Vishwas. All right.
Opposition copy to the.
Are you a job loser also? Because
Yes.
you were there.
We are teachers of
And-
class 9 and till 9 and 10, my lord. My lord, we have our contention is that, but award of 10 marks for teaching experience should be awarded to all, irrespective of their classes. whether it is 9, 10 or 11, 12. Here the contention of the petitioner is that the award of 10 marks should not be awarded to teachers of 9 and 10 since they are not taking classes of classes 11 and 12.
No, you are not clear. Frame it differently. You are not clear.
But-
You are not ready. I can understand.
10 minutes, madam, kindly allow me
I
10
can
minutes.
understand. Yes, you.
madam.
Yes, right.
Well, I have the
Reply.
reply.
আমি reply copy পাইনি।
Which matter?
This matter 37.
37. Yes.
I filed
Your
reply.
allegation is that
Malad ki-
experience of 9, 10 cannot be considered in 11, 12. Yes, place it.
Madam, we have not received the reply.
All right, he'll serve. Yes.
Well, kindly in paragraph 6, my lord, in my reply.
All right, paragraph 6.
That my lord, with reference to the statement when the paragraph such and such, well, I deny and dispute it state that 2025 recruitment rule, the teaching experience marks are categorically segregated and mentioned separately for recruitment to the post of the assistant teacher in 9, 10 and 11, 12 classes as because the selection process, the academic qualification are different and written test was held differently. For that reason, the marks of the teaching experience for the post of assistant teacher in 9, 10 and 11, 12 class are mentioned separately in the said notification. But the School Service Commission, by violating the aforesaid circular, granting the marks of the teaching experience for the 9, 10 in school, the post of 11, 12 classes, this classes teacher recruitment, which is not maintained with the eye of law. Second, my lord,
No, I could
The-
not follow. I could not follow this.
but there is the two separate
একটু
recruitment
দেখি,
process.
ফাইলটা একটু দিন না। Item 37. Yes, read petitionটা।
আমাকে দিয়ে বলতে হবে, report আছে।
Hmm. Place the rule
Page, my lord, 74. Page 74, my lord.
74.
Yes.
হ্যাঁ, থাকুক। Yes.
By schedule 2. My lord, the kindly see, my lord, two separate, my lord, the procedure for, my lord, the marks is also, my lord, the difference and teaching experience, my lord, written categorically different. So, my lord, there is the two posts. One is for the 9, 10, 11, 12, and another is the, my lord, the 9, 10 and 11, 12. Two separate selection process. There is the qualification is the different and written test also difference. For that reason, matlab the two, matlab, the teaching experience, matlab the written separately. So, matlab they have no teaching experience in the 11, 12. So, their marks for the teaching experience given for the post of the 9, 10 for the 11, 12, that is one of the contrary of the law. Because one of the 9, 10 teachers have no teaching experience in the 11, 12 class. Now, that's why one of these marks should be given for the particularly teaching experience for 9, 10 for the 9, 10 teachers and 11, 12 for the 11, 12. That is one of the contention and the rule has been framed for differently and one of the teaching experience marks has been given differently. So,
No. See, schedule 2, first is for 9 and 10.
yes,
Prior teaching experience 10 marks at the secondary level.
yes,
And in 11 and 12 also, prior
B.
teaching experience is 10 marks
yes,
at the secondary level.
yes.
So it is the same thing.
No, this is one of the two different posts and one of the qualification
is
is the different. Qualification is different. And the well-settled principle of law, they are one of the working in the lower post, their teaching experience cannot be treated for the higher post.
Where is that?
Well, kindly the judgment. So, well, I am placing one of the
What is the qualification for 9, 10?
9, 10, malad, they have some, malad, some candidates who are also working in the 9, 10. During the, malad, the service period, they enhance the qualification and subsequently thereafter they applied for the 11, 12. Malad, they are putting their experience for the 11, 12. That is illegal. That is not permissible under the law. Because I have posting, malad, I have holding the as a PG teacher malad, with the graduation and BEd. And thereafter, subsequently, I working for the 5 years or 10 years in the 9-10 school, and subsequently I enhance my qualification and I apply for the 11-12. I have giving the marks, teaching experience marks for the 9-10, that is not permissible because teaching, the identity code is the one.
1 minute, 1 minute. The educational qualification required for appointment in 9-10 and 11-12 is the same. See page 73.
Pay scale is the difference.
Pay scale is different.
It's different.
Different
The
thing.
selection process is different. Post is the different. There is the below post. The 9-10 and the 11-12 not the similar categories. There is their post because that's why this is segregated. Because they are working for the higher category. They have already they have teaching experience and they applied for the teaching experience in the for the 9-10 school, and they are taking the double benefit in the for 9-10 school once and the 11-12. They are the teaching experience. They are the code of the teachers is the one. And they are they have all they have to be granted the teaching experience for marks for the one category. They have taken the double benefit for the 9-10 school one for the same category and then the 11-12. That is one of the rules. That's why the rule has been prepared. The rule has been categorically stated for the subject that post in which post they has been working. Suppose one candidate the enhanced qualification in another subject, they apply for the 11-12, they are not entitled to get the marks teaching experience for the 9-10 school. That is the contention before Lordship because this is the in that case what happened all the untainted teachers who are applied for the 11-12 they are not getting the chances because the 9-10 school untainted teacher they applied for the both posts and they getting the marks for the 9-10 and 11-12 they have been double benefited.
How can there be double benefit?
Because they have taking the marks for the 9-10 school once and 11-12. One for the one teaching experience, they are getting the 2 marks for the 9-10 and 11-12.
Selection process. Selection process is different.
Selection process is
It is not
different.
that 10 plus 10, 20 marks they are getting.
No, that is they have
Then-
given the double benefit because the 9-10 school is the different.
Yes, that
The post
they
is
have
different.
their experience, whether they teach in 9-10 or in 11-12.
Yes.
Wherever they compete, they use this experience.
Use experience for that post only because for 11-12 they have no teaching experience. They have experience on the 9-10 school in particular subject, but in the 11-12 they have no teaching experience. So the putting question of myself, they have working for
You show it by backup by judgments or anything.
But another point is about the paragraph 7 also. Now I am placing the judgment. Paragraph 7 is the lower post working experience not taken into consideration for the higher post. And kindly see the page 6 of this my opposition. Reply.
Yes.
Well, last portion, we kindly see page 6 in paragraph 8. This also stated that those who are working in the teaching in 9-10 school and subsequently thereafter they enhance their qualification in other subject, they have also applied in the post of assistant teacher in 9-10 school and they are also included in the call for verification list by putting their teaching experience in 9-10 school in other subject. As a result, those who are appointed with the higher qualification in 11-12 school, they are deprived of getting chance to appear in the interview for the post of assistant teacher in 11-12 school, though they have teaching experience in 11-12. my lord, once. For 2022 SCC online Kerala 7024.
Here your status is a job loser or what?
Job loser.
You are a job loser and you are contesting for 11
11,
and 12.
But what happened, my lord, due to my lord, the untainted teacher of 19 school, they applied for the my lord, the 11-12 school. My lord, for that reason, my lord, the others, those working for the 11-12 school, not getting the chance.
Why did you not apply for 9 and 10? Was there any particular reason?
No, because we are holding the higher post. That's why, my lord, I have applied for the 11-12.
Yes.
Paragraph 14, 15, and 16. One of the prepositions they teach, the teaching experience should take into consideration with the the requisite qualification when she is working in that post. Paragraph 7, my lord, kindly see. My lord, kindly see page para 4, my lord. The giving the discrimination, my lord, their appointment and teaching
1
experience.
minute. This is in the matter of Dr. Asha Sridhar.
Yes, yes.
Paragraph 4.
4 is the my lord, tabulation sheet.
Yes.
Their date of appointment and experience and everything.
Hmm.
Considering this, my lord, paragraph 7.
Paragraph 7.
Hmm.
Yes.
It can be seen from the table above, the Dr. Padmaja Devi and Dr. Asarada obtained their PG qualification only in 2005 and April 2006, respectively. After they are also promoted in reader, assistant professor, Dr.
Whatever.
Yes.
On the other
On the other hand, and obtain her the PG qualification even by the time of her initial appointment as a tutor. It was therefore her case before the tribunal that although it has been fact that Dr. Padmaja Devi and Dr. Asha Sridhar adopted their PG qualification with the extended period granted under the special rules of force, the period spent by them in the various posts where PG qualified was prescribed as the essential qualification could not be counted towards the teaching experience required for the post of professor, where also the PG degree was prescribed as essential qualification. She also relied on the provision of the such and such. But this is the contention, Maladi, that time when the dictionary is working in that post, there is the qualification and higher qualification that experience would be calculated for the post of the higher post when is the promoted. In this case, those the teachers is working in the
What is the judgment? This is the contention.
contention, and this is the last portion, my lord, kindly see page paragraph 10.
Yes.
Pre-contra argument.
That is the
yes,
submission.
this is
What is the
submission.
finding
And
of the court?
kindly see. Paragraph 16, my lord.
Yes.
In my view of the matter, we find that the argument of the Learned Session Council of the petitioner before us, in view of the exception and relaxation granted to them for the obtaining the essential qualification PG, they should be seen having gained in the acquired teaching qualification of the PG teacher in the various posts, and they had occupied cannot be illegally counted we related that the teaching experience prescribed under the PESA rules has to be read along with the provision of the 10AB of the part of the such and such, and the light of that center regulation holding the field, and when so did the 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 teaching experience can only be one that is qualified after the acquisition of the essential qualification required to be the post of the professor. We see no reason to interfere with the impugned order of the tribunal, and for that reason, the supplement and the reason, the judgment, and this is to be one of the
How
considered.
does it fit in your case?
Because Manat, I have one of the holding those one of the working in the 11-12 without the qualification to apply for the 11-12 school. That experience cannot be taken into consideration for the post of 11-12 because
How does the facts of this case fit in your case?
because Manat, these persons who applied for the promotional, when the working with the higher qualification, that experience would be calculated for the higher post. Because other two candidates, they obtain their qualification after that, that time experience cannot be taken into consideration. This is the contention and proposition.
What you are submitting is something too very general. See, somebody applies for 9 and 10 working. He or she enhances the qualification later on and then
Applied for the 11-12
11-12.
by putting the experience,
Right.
when that time there is no qualification. That
Qualification.
is.
Right. Now,
So, somebody have the with qualification and somebodies are without the qualification for the higher post. That will not be segregated in just in this way. But that's why the rule has been framed. And the two categories of the classes of the teacher, 9-10 and 11-12, for that reason, but two separate teaching experience marks has been given. Because if the common things, then the only one clause is there. All our teachers will entitled to get the marks for the 10 for their teaching experience. There is no necessity, putting question of myself.
suppose somebody doesn't have the qualification of teaching candidate in 11-12. Somebody doesn't have. He only has the qualification for teaching in the secondary level because that is what the rule says, secondary. That person is also eligible for 10 marks for being appointed in 11-12 category. What is your submission?
My submission is suppose the secondary. There is no specific rule for the 11-12 and the 9-10. All are secondary. Even in upper primary school, but there is also included in the secondary level. For upper primary school, there is no such rule for the others. They all are secondary levels. So, in that case, upper primary teachers not taken into consideration for the teaching experience. If we are all in the one cloud of secondary, so the upper primary teachers would be granted the marks for the 10th. That is not. But that's why segregated. The 11-12 teachers will be entitled the marks for their teaching experience, and the 9-10 they are separate the marks for their teaching experience. But that's why the rule has been framed. And subsequently, what happened? The School Service Commission initially decided. This is my thinking, that is segregated and rule has been framed in different way. This qualification, teaching experience, everything is different for the 9-10 school and the 11-12 in differently, and they have framed the rule and two way because there is the two categories and the experience marks also given separately. If in open to all the giving the marks for the teaching experience, there is the one clause. All are the teachers will entitled to get for the teaching marks for 10 marks. What is the necessity the putting question of myself to separate category and to separate teaching experience? So that is intention is that the 11-12 teacher will not get the marks for the 9-10 school, and 9-10 teachers will not get teaching experience marks for the 11-12. Even one thing is that in the application form, one is the teacher's the one code. So one code, one teaching experience has been allotted. But subsequently, school service commissions changed their view. They're giving the marks to 11, 9, 10 school teacher for the 19 school and 11, 12 school. But that is what is the necessity of the making the rule for in different two categories. There is no necessity because each and every person who applied for the post, they will get the marks for the 10 marks. That is not. That's why they frame the rule separately and they indicated separately in the teaching experience. So this is highly illegal in 9-10 teachers. Those have no teaching experience and no have qualification for the appointment in the at the time of their working. They have applied for the 11-12 school. And my learned friends, another contention is that they are the examiner of the 11-12. And for that reason, they're claiming for the experience marks for the 11-12 school.
Only examiners.
But they have putting their in the application for additional party. They have work also the 11-12 school. Some works for that is they deserve the marks of the teaching experience for 11-12.
That means it not teaching work.
Teaching works, this is the some extra work. We are working for the 9-10 school. I have also look after the examiner of the 11-12 students. That's why I'm not claiming for this is the judgment.
I did not follow. I did not follow.
The one those have the teacher of the 19 schools. They the examiner of the 11-12.
Examiner means what? He looks after, he checks the answer scripts in examinations. 9-10 teachers.
Yes.
Checks answer scripts.
Yes, that is they let them state has been they have given the papers to checking for the
if they check papers, that means they have that qualification to check it. Otherwise, how
no,
check?
it is not. That is there is the judgment of the 1991 supplementary to SSC 733. If I have holding the lower post and I have looked after the upper post and doing the work, I am not deserved for the entitled to promotion for showing I have the experience of the that.
This is not a matter of promotion.
But this is the related to experience and the qualification.
Whether the experience of 9 and 10 can be counted.
Yes,
or
yes.
11 and
I have
12.
stated, make my submission because they separately they have framed the rule, and there is the to separately they have given the teaching experience. The rule itself, the displayed that there is the two category of the selection process, two category of the post, and pay scale is the defined. So, the lower post holder cannot claim for appointment by showing their teaching experience for the 11-12 school.
Yes.
But another judgment is the 1991 supplementary to SSC 733.
देखिए judgment টা দিন। Yes.
Paragraph 5, my lord.
Paragraph 5.
Paragraph 5 onward.
All right.
The argument in contemplation of the order plainly do not amount to a promotion of the appellant to the post of the lecturer, treasurer. The distinction between the situation where the government servant to promoted to the higher post and one where he is the merely asked to discharge the duties of the higher post is too clear to inquire and any reasonably asking and the officer who subsequently hold a lower post merely to discharge the duty of the higher post cannot be treated as the promotion. In such a case, he did not get the salary of the higher post, but gets only that the service parcel in the call to change allowance. Such situations are the template where the exigency of the public service necessities and arrangement and even consideration of the scenario do not enter into the contention to hold that the substantial lower post only discharge the duties of the higher post essentially is to be the stopgap arrangement. And last one of paragraph 7, the second contention is that the definition of the expression absorbs post and absorption employee in section 2 of the act is wide enough to take into their sweep not only a person holding the absorbed post in before December 20, 1961, but also one who has merely serving in the higher post and that accordingly such higher post also render in relation to the persons as a absorbed post. We afraid this construction is clearly unsupportable. And paragraph 9, my lord. The third contention is the appellant in charge arrangement in the higher post had contended for so long a period that determination of the equivalence on the basis of the lower substantial post would become arbitrary. This contention ignores the fact that in charge agreement is not the recognition of is necessarily based on the seniority and therefore no rights, equities and exceptions should be built upon. The third contention is that the unmeritorious.
So this was a stopgap arrangement. Somebody.
Yes,
was
that is
working.
Maladi, they have given the work, they working, so they cannot claim they have working for that post, that is, I have they acquit the right to promote in that post. So in this wise, they are giving this, they are taking the examination from the 9-10 school, 11-12. So that's why I have the
Experience
their
of-
rights. Yes, yes, that is the Maladi contents. So, Maladi, as per recruitment rules, as well as Maladi, as per experience, they cannot claim for Maladi teaching experience for the 11-12 school. Suppose one candidate Maladi working for the another, some subjects, the NS qualification and other subjects, they apply for the 11-12 school for showing that subject, but taking into the Maladi experience in the 9-10, that is not permissible under the law.
Yes.
So, Malad, in my reply, I have stated, Malad, in paragraph, I have already, Malad, the submission before Lordship on paragraph 6, 7, and 8 by considering, Malad, the case, kindly not allowed to, Malad, 9-10 teacher to participate in the, with the marks of the teaching experience of 11-12.
Service Commission Act.
See, there are many cases which I have got where postgraduate degree is there, the teacher is qualified for being appointed in classes 11 and 12, but then the teacher is actually appointed in the lower classes, say 9 and 10. Due to vacancy in 11, 12, these teachers are directed to work in the 11, 12 section and they regularly teach there. Can their experience not be counted?
But one
Though their
is-
regular appointment is in 9 and 10. Their appointment is not there in 11 and 12. But they are regularly taking classes of 11 and 12 because they have got their qualification. For the sake of the students, they are doing it.
they have taken the classes, but there is no authenticity, there is no permission for taking the classes.
There,
Because
definitely there is
this-
permission. Otherwise, how can the
Otherwise,
teacher?
they have paid for them on a higher scale of pay.
No,
That is
no,
the
those-
pay scale is the difference. So if I am working in the 19 school, I am taking classes for the 11, 12 with my qualification, so I can apply for the higher scale of pay.
Assuming somebody applies and gets the higher scale of pay,
Yes.
then
But there is no the microscopic way to segregate it.
yes.
Because that is the point. If how can I segregate it? So those have the with qualification to be applied for the 11, 12 school. And that is
So
for
what
that
is-
reason, for that reason, the rule has been prepared by category wise, the 9, 10 differently and 11, 12 differently. Among marks as teaching experience also have been given in different ones. So that's why they have framed the rule. But this rule has been prepared in continuation 2016. This is not the common recruitment process. As per order of the Supreme Court, this selection process is conducting. And also, the review petition, they have given the benefit to the untented teachers. The one thing is that, maximum untented teacher, in the 11, 12 school, due to this point of my argument, they are not getting to chance to their recovery of their service because due to maximum 11, 12 schools in that in the working period of 6 years, they obtained the master degree and higher qualification and they applied for the 11, 12 school. So, without the qualification, if they working for 6 years, in the 6th year end, they have applied, they obtained the qualification in the master degree. Without they have getting the marks, 10 marks for the 10 years experience, but 6 years experience. That is impermissible because that time they have no the qualification.
Yes.
That's
Because of that separately address, my lord. And senior friend, my lord, Mr. Dhar, my lord, addressed that the definition of secondary education is there, my lord, but I believe is not go through the definition of
Yeah, you will reply. I'll hear Mr.
because
Sanyal.
it will be kind of because Mr. Sanal will give the reply that will, my lord,
Give reply. He will
He-
place it. He is the applicant.
applicant, that means he wants the benefit, but which is not permissible. I just show it, then it will helpful for him to give the reply. Because of that, that secondary education definition is obviously is there. And there is also higher secondary education is also different. And that 9, 10 qualification and 11, 12 qualification is not the same. Kindly see the rule, my lord. Kindly take up the rule, my lord. And my lord is,
25 rule.
yes, my lord, 25 rules.
না না বলতে বাধা দিস কেন বলুক সবাই বলুক
Well, kindly see the schedule 1,
Hmm.
the 9-10 qualification, educational qualification. This column, schedule 1, got it? Malad?
Graduate, postgraduate.
Graduate oblique postgraduate. So any of the qualification is for the 9-10. Now, Malad, kindly take 11-12.
Postgraduate,
Only postgraduate.
right.
So 11-12 category, a 9-10 category teacher never get the benefit of the 11-12 category. Why? Suppose a 9-10 category teacher, he have a graduate degree,
No, suppose a 9-10 teacher having postgraduate.
postgraduate degree. In another way, my lord, I taking up. My lord, NCT says, my lord, because NCT segregate the class 1 to 5 primary, 6 to 8, that is upper primary, 9-10 is secondary, and 11-12 is the higher secondary. In the regulation 2014, my lord, in last occasion, my lord, I handed over, my lord, because this rule is also says that they will follow the NCT. NCT regulation 2014 is very specific for which category teacher got the benefit for which category. In our High Court, one of the division bench, I believe Mr. Shanal is also appeared in that matter. And that question arose first time in the primary matter. In the primary matter, some of the upper primary teacher, para teacher, they want benefit in the primary. Single bench allowed it. If I not subject to correction, if I am not wrong, my lord, out of my memory, that West Bengal Board of Primary Education went to the division bench. Division bench says no. Upper primary para teacher not get the benefit of the primary. Although upper primary is the in higher pedestal, but they are not entitled. Why? Because of that, my lord, he might be take class in that category. That doesn't mean they get benefit of that class or that experience. Because of that, in the 2016 selection process, suppose because this rule is clubbing of all, but the earlier selection process, also this selection process is also the separate selection process is conducted. 9-10 separate selection process, 11-12 separate selection process, upper primary separate selection process, primary separate selection, even primary by the separate authority itself. Suppose if the benefit is given, the even a 11-12 teacher got benefit 9-10 or vice versa, then my lord, same question will arise in the case of upper primary. Same question will arise in the case of primary. Then every teacher is going to get benefit for everywhere, specifically who are in the higher pedestal. Suppose a primary selection process is going on. I just give an example. Secondary or higher secondary teacher, they take class of higher classes. So he might claim the benefit of the primary, but the primary benefit he will not entitled because he is not appointed in that particular post. And NCT also segregated that particular class, as well as in our state, there is an act, specific act, education manual. It will be kind enough, I'll take the education manual. Our said volume 1.
Headmaster's manual?
No, my lord, education manual.
Education manual is not here.
This is the volume 1, my lord. I will show just, my lord, 3. One is that West Bengal Council of Higher Secondary Education Act 1975, and another one is West Bengal Council of Higher Secondary Education Admission and Allied Matter Regulation 2006. That is page number 812. That is West Bengal Council of Higher Secondary Education Act 1975. Section 2, subsection D.
Yes, higher secondary education.
Higher secondary education. Higher secondary education, except in relation to such class of student as the state government may specify, in this behalf means such education commencing after the terminal stage of school education. So it is specified school education in the pattern of secondary education. So it is after secondary education, introduced with effect from first day of January 1974, which concludes with the passing of the public examination, but by whatever name called and instituted by the West Bengal Board of Secondary Education, as is provided for students with a view to qualifying them for admission to diploma or degree course instituted by a university or by government or by statutory body, and includes subject to any general or special order of the state government education in humanities, science, commerce, agriculture, technical courses, or other courses, vocational or otherwise, which the state government may, in consultation with the council, specify. That's why, my lord, will remember, we filed the get benefit of that vocational teacher, because in higher secondary education, vocational education is also included. That's why the vocational teacher wants the benefit of the 10 marks, my lord. But they not give it. In contrary, they gave the benefit to the secondary teacher in the higher secondary level. My lord, kindly take, my lord, West Bengal Council of Higher Secondary Education, Admission and Allied Matter, Regulation 2006. So, my lord, here, my lord, they specifically in this regulation, this admission in class 11 and 12, the whole regulation is important. For the saving of the time, my lord, where my lord specifically narrated what is the meaning of the higher secondary, how they will take admission, my lord, after this council act, my lord, my lord, after the council act, my lord, regulation 1976, thereafter regulation 2006, my lord, the examination regulation, thereafter admission regulation, and there is specific mentioning the admission in class 11 and admission in class 12, my lord, specifically narrated. So higher secondary means classes 11 and 12. And kindly take that, my lord, that regulation 2014 of the NCT. NCT একটা bunch এর আগের দিন দিয়ে দিলাম সেটা। মানে last day, my lord, I remember, my lord, I handed over a bunch of NCT.
All right.
Petitioner, ওটা additional point যেটা argument হয়নি, স্যার বললো তোমরা অ্যান্সার দিবে, তোমরা তো আলটিমেট। ওই পয়েন্টটা তো বলেনি, ওই পয়েন্টটা তো লাস্ট ওকেশন, no, 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 no. Malad, last occasion, Malad, I handed over a bunch, Malad, where Malad, the NCT Act was there as well as the regulation.
Understand.
Malad, just show, just one tabular chart is there, Malad,
All
where
right.
Malad specific mention about the classes. What class means what. But kindly see that tabular chart. NCT বলে লেখা আছে। ওটা না, NCT।
ওটা নয়।
এর আগের দিন দেখে দিচ্ছে, পরের দেখে দিচ্ছে এর আগে।
Yes, NCT.
NCT Regulation 2014. Malad, here is the name of the regulation. This regulation may be called National Council for Teacher Education, within bracket determination of minimum qualification for person to be recruited as education teacher, physical education teacher in primary, 2014 regulation. That's
All right.
2014 regulation. Where, Malad, in the first schedule, Malad, that is mentioned, what is the meaning of preschool, primary school, pre-primary school, upper primary school, secondary school, entry 4. And here, my lord, the same qualification. In entry 4, minimum qualification is narrated, secondary stroke high school, within bracket for classes 9, 10, graduate stroke postgraduate, the same qualification, because they follow the NCT. In the rule itself, they mentioned that they follow the NCT minimum eligibility criteria, because they ought to follow. According to NCT Act 2011 amendment, because NCT earlier,
Yes.
NCT earlier was a dedicated institute for supervising the Teachers Training Institute. Thereafter, after coming to the Right to Education Act, there is a amendment in the NCT Act itself. And after amending the NCT Act, Section 12A, my lord, you remember the last occasion I referred it, Section 12A was introduced. And that, by virtue of that amendment, the NCT being an academic authority, because the NCT becomes the academic authority in pursuance of Section 23 of the Right to Education Act, because central government appoint NCT as an academic authority. Thereafter, NCT, for bringing the standardization of the school education, they floated this minimum eligibility criteria concept. Thereafter, NCT, first time in the year 2010, came up with a notification, the minimum eligibility criteria for the classes primary 1 to 5, there, as well as the 6 to 8 in the year 2010. Thereafter, 2011, there was an amendment. Thereafter, regulation 2014, the first time. The first time in the regulation 2014, they says the minimum eligibility criteria in the classes 9, 10 and 11, 12. That is in the high school level and secondary level and higher secondary level. So in the first time in the year 2014, they came up with this regulation with that minimum eligibility criteria. So after that, my lord, when they specifically denoted that higher secondary education, in the earlier selection process also, there was a dedicated selection process in secondary as well as the higher secondary. So if you give the benefit of higher pedestal teacher or higher classes teacher, then same benefit ought to given for the primary also. Who is the upper primary teacher, they also get benefit with the primary. Who are the say higher secondary teacher, get benefit the secondary. Even he also get benefit of the primary also, because he is the higher pedestal teacher. So my respectful submission in this regard is that, my lord, it is not that. Whosoever dedicatedly appointed for that particular class, only he get the benefit of that particular classes, otherwise not. If he want to participate, he might participate, but he not get experience number for that particular. And not only that, my lord, in higher secondary definition itself includes the vocational teacher. So that's why, my lord will remember, we were once benefited the vocational teachers also. They are entitled 10 marks benefit. That's why for the time being, my lord, after submission, my lord, my senior will repeat.
বলে দিচ্ছে সবাই এখানে শিডিউল 2টা কোথায় বলছে?
এই তো শিডিউল 2 স্যার রানিং পেজ 11 ও শিডিউল 2 ফলো করবে ডেফিনেশনে বলা আছে, ডেফিনেশন বলা আছে এই তো এটা
Yes, Mr. Sanyal.
ওই জাজমেন্টটা নিয়ে তো
তুমি পুরোটা স্যার আমি এদিকে চলে যাই
You are here in Bishwajit Biswas's matter?
ইয়েস
Yes, ma'am. Can 4.
In Bishwajit Biswas?
না না এটা বিশ্বজিৎ বিশ্বাস নিয়ে হচ্ছে
You want prior teaching experience marks for 9 and 10 to be given to 11 and 12.
But I'm appealing for both 9, 10, 11, 12. I'm asking for both.
স্যার আমি একটা কথা
Yes. 11, 12, you have worked, you've got experience, it's all right. But if you have not worked in the 11, 12 level, you have worked only in the 9 and 10 level, whether that marks can be awarded in the 11, 12 stage or not. This is the question.
Well, this question, according to me, itself against the rules.
Yes.
Your losses kindly.
That is the challenge to the rule.
Huh?
That is the challenge to the rule.
No challenge.
No challenge.
Kindly have a look at the prayer. I take your losses.
I do not know in particular matter whether this is challenge or not, but the submission is that it cannot be.
That's your losses. Kindly, I'm ready to take your losses to that. Page 23.
Yes.
prayer B. I will place before your lordships both the prayer B and C. To publish the notification by mentioning the special benefits which should be given to the untainted teachers in connection with the second state level selection test 2025 by considering the order dated 5th August 2005 passed in review petition being such and such. Then C, to grant the marks of the teaching experience in favor of the candidates, those have the teaching experience in the respective subjects and position in the same school where he or she was working and presently applied for, and also issue the notification mentioning the teachers of the 9 and 10 school are eligible to get the marks of teaching experience only for 9 and 10 school, and teachers of the 11 and 12 school are eligible to get the marks of the teaching experience for 11 and 12 schools. What they are praying for before your lordships, rewrite the recruitment notification. And then your lordships will find prayer D, to publish the notification by granting full marks for the lecture demonstration by considering that the petitioners are working as untainted teachers in connection with the state level selection test 2016, and further direct to publish the fresh notification by giving clarity that the lecture demonstration marks will be granted to untainted teachers, those who have acted in accordance to 16. And then your lordships will be getting, kindly come to your lordships, F, certiorari, happily vague, delightfully vague. What they are questioning, Malab? So what today they are asking for, rewrite the notification. It's a basic principles of pleadings. Can they, Malab, ask? I'm concerned with that your lordships have enough jurisdiction to do anything, but not to do contrary to law. This is the prayer all they are arguing for all days. And now kindly have a look at paragraph 9 of the writ petition. This notification, rules, everything is published, your lordships. Kindly paragraph 9, page 14. That your petitioners state that the petitioners have made application for recruitment to the post of assistant teachers in SLST 2025 selection process. Admittedly, this was made. They have subjected themselves to the process, knowing full well this is the rules. Then they are now appearing, they say rewrite the entire process. This is according to me not permissible. Then they ought to have first questioned the rules. Prayed before your lordships, my submission, of course. That allow me to appear subject to this challenge. I could have understood that. That doesn't mean, my lord, I have a quick case. I have a very good case even on merit. That I will satisfy your lordships. Then your lordships, kindly take up the rules itself. I take your lordships the page. I just give your lordships.
What is your status?
My status, untainted teachers, I'm still working. But I have applied for both because I have the qualifications. Both. Your losses will astonish to see some of the cases that I'll be moving again, just out of the records. I applied for both earlier. In the 9 and 10, I got selected from the main merit list. I was working. I worked for 9 months. Then
2016.
Then I got, this is not the present one, but I'm giving a losses. Then I got a call letter for 11-12. In the 4th counseling, I appeared. Everybody wants better job. If I today give something, I will also go. I appeared, I got selected. Now everything lock, stock and barrel goes. Now the question comes up, how can I be said to be tainted, untainted? First of all, because I got selected in the first merit list in the 9-10. I was working for 8 months. Then I was called by the council, board by council. The appear 4th council. I gave, went there. got selected, appointed, and now say everything bad. Now, another aspect to your lordships, I don't know, everybody probably will argue. Now, my lord, principle of weeding out is being long followed by the Honorable Supreme Court also. This is also not in the present context. Now, your lordships had got the entire details. Who are rank jumped candidates, who are out of panel appointed candidates, and whose blank OMR seats or mismatch of worksheets. My lord, had those candidates not been selected illegally, I would have been at the top.
Although submission will not.
My lord, kindly wait, my lord, your loss is now open to all according to my submission. Your losses can take into that. Now, therefore, I have been suffering for somebody's wrong action, not for my fault.
Maybe the entire selection process.
That's one aspect. Therefore,
Everybody is
that
certain
is submission.
corrupt.
This submission only confined to that I'm not tainted at any means. Now your losses kindly. Therefore, he applied for that selection process. Now your losses will find. Kindly look at the rules. It starts at page 64. This was rules was published in 29th May 2025. So everybody was put on notice that this will be the rules. Petitioners applied according to the rules. Selection process is governed by the rules. Now kindly have a look your losses. Here your losses will not find any definition of secondary level, higher secondary level. But I will deal with Mr. Samim's submissions in regard to that, because everything should be determined on the basis of the rules when there is a codified law. Unless, my lord, somebody questions it and your lordship holds it, this is unconstitutional. That's a different. Unless this is done, everybody has to go by the rules. Now here your lordships will find, kindly come to Schedule 2. Page 74. Selection to the post of assistant teachers for classes 9 and 10 shall be made. This is for 9 and 10, but I will be precise. B, at the secondary level. It doesn't define. Secondary level doesn't define, my lord. I have worked, at least not upper primary up to class 8. So rule conceives according to me, as soon as upper primary ends, terminates at class 8, rest as secondary level. Clear to your lordships? Because I tell your lordships, their argument is self-defeating. Then if they construe it to only up to 10, then they will not be getting any marks either. Because kindly have a look at the next page. Prior teaching experience at the secondary level. Now, what if your losses read with this, with their prayer, they are trying to give your losses, rewrite the entire law.
No, their prayer may have been framed differently, but the submission is that 9-10 experience cannot be taken up for consideration in the 11-12 stage. This is the sum and substance of the argument. But the prayers does not appear to be framed
Entirely,
properly.
because they're conscious of it. Why they have made it? Because they're conscious about it. Unless there's a fresh notification, this kind of fresh law rather. Notifications means fresh law again. How could they ask for it? And now your lordships with this, can you look at page 31 side by side? Why I'm saying it, your lordships? Page 34, one of my application.
31 of your application.
Now, keeping it open, your lordships.
Yours
Requesting your lordships.
can
Can 4.
এই মামলার ক্যান ফুডটা একটু দিন তো। বাধা আছে না? ঠিক আছে। Yes,
তো ক্যান 4টা দিন, অতগুলো মোটা দিন।
all tied. Page
Page 31.
31. Yes.
Now kindly see this. This is issued by the West Bengal Council of Higher Secondary Education. I was admittedly, my lord, working as 9, 10 teachers. I'm taking their language because according to mission, appointment letter come meeting notice of examiner and scrutinizer. This is given not by the board but by the higher secondary council. I am directed to appoint you both as examiner and scrutinizer for the subject mentioned above for higher secondary examination 2025. You are requested to read and follow the instructions, date of meeting with your head examiner, and the schedule of submission of marks in 2 installments as furnished below. I am also directed to draw your attention to the government notification of such and such of 2000, which has stipulated that evaluation is an essential duty of the teachers. Now I am putting a question to myself. Now I am an admittedly a teacher of class 9 and 10. Now I am being asked by the council itself, not by the recruiting agency, commission, do and examine the papers and be the scrutinizer. Somebody's are head examiners also. Now, here your losses, I give your losses, since your losses have experience from this side, both sides. Now it's open, Malad, I have all the qualifications, very good qualifications up to postgraduate levels. Your losses have noticed by this time that everybody wants to pass graduate. Why, Malad? Because he had the knowledge much, but he wants to compete with the lesser qualified so that get the chance. This is for entry. Then higher scale comes your losses, lots of matters. Now suppose your losses, I have got a graduate grade teacher, but I have all the qualifications. I am being utilized like this. Does it not amount to teaching experience gathered by me? Now see, and kindly page 32, I am taking the classes even. That's why it has been kept open consciously by the subordinate legislature secondary level. That's my submission.
This is what I was just now mentioning, that there are many teachers in the 9 and 10 level who have got the postgraduate degree, but they are directed to perform or discharge duties of 11, 12, but actually appointed in 9 and 10.
Plus,
Will they
appointment
not
may
get?
exactly appointment may be subject specific to a class specific, but he had the qualification. Once you have entered into a school, you have to do whatever required for education, and that's why terms becomes secondary level. It benefits both of us. Then if the secondary level your losses they have to construe it, then entire selection process rules has to go. That's not the question. That's you cannot do it. And this is your losses, the higher secondary council is doing it. In all the matters your losses, most 99%. All secondary school teachers, if your losses, this is the restrictive meaning up to class 10, are taking classes of 11. Otherwise, no school will have. At least in our state. I don't know the other state. And I will take your lordships. Or somebody will jump up and say the central government policy has not followed, has not accepted by this government, but the rules say so. National policy of education says secondary level education means from class 9 to 12. But your lordships, I am conscious of that national education policy has not yet been implemented by the state. But the national policy is that. Because of the Schedule 2 under the Constitution, it's a state domain. State can. So this secondary level has been used, the language expression by the subordinate legislature consciously, so that's to extend benefit to both of them. I don't know why they are fighting with us. It's a merit position. Then may I conclude it? You are so intelligent, you can't teach the lower classes. That means the submission restricts to that. Then a doctorate candidate cannot teach class 9, 10. There are losses, PhD holder teachers. Because they're so educated. They can't get the fathom of the mental intellectuality of a minor student, of young students. Because they are for the higher classes. These submissions is not for your losses, really for the honorable read courts. This is for the authorities to decide. They will decide. This doesn't harm anyone. It doesn't take away his right to be selected. Does it take away, my lord? He is entitled to. He is also getting.
The competition increases.
Malad,
We
that's-
will always want the competition to be less.
Ma-
Everybody wants.
Malad, what they wanting to restrict competition to themselves.
Obviously, to
Malad, that's
the
that's not the
teachers,
law, probably.
the 9-10 teachers.
That cannot be the law.
Not the 9-10, the 11-12 teachers.
This cannot be the law, my lord. Because the authority will use the teachers according to the need of the school, according to the need of the students. It cannot be restricted, and that's why the rule has been framed like this. My submissions, your lordships.
See, submission has also been made that a teacher is teaching appointed regular basis in the 9-10 section. The teacher enhances qualification in a different subject and then teaches 11-12. Goes for higher scale of pay and all these things, but regularly appointed in the 9-10 section. Will that teacher also be given the benefit of 11 and 12?
Not according to me.
Various.
Not according. I tell you, lordships, when I crossed the school, Malad, our all geography teachers were from commerce section, if not wrong.
Yes, then what is
That's
to be
all
done?
for commerce section because they had the commercial geography. No specific geography teachers we had in our student life.
No,
That's back
that's
then.
different.
Different. Now, your lordship, all that I'm trying to say, your lordships, qualifications of the teachers should not be restricted. They will, the more they will teach themselves, the more
That is
they.
different.
So
That is
therefore, it
different.
should not be restricted to anyone. If you have the experience, if law permits it to be considered, that should be considered. Law is not challenged like this. They say rewrite, republish.
Well, in this matter, maybe the prayer is not happily drafted, but there are matters where a specific challenge to the rule is there.
That's Malad, on the teaching experience.
Teaching experience.
That's Malad. Yes, Malad. And then your losses, Malad.
No, first the court has to decide whether this prior teaching experience marks can be given or not.
That's-
Thereafter, whether 11-12 and
That's another aspect, your loss. But I am confining my submissions to the present writ petition that this should not be permitted like this.
all right.
These are my humble sir.
My lord, with leave of my senior, my lord, I made a wrong submission. In this matter, we have not filed in opposition. I stand corrected, my lord.
Not surprised. And sorry, give me 1 second. Sir. Mr. Samim is here. Mr. Samim's juniors. Malad, primary, upper primary, out of Malad, context this was submitted. I tell you, lordships, the rule says only primary teaching experience to be taken, not the upper primary. So this was not cited, just Malad, running submissions. So your lordships, my submission, this should not be considered, taken into consideration. If that, then I have to give a reply to that. There's a rule permits. Rules only says only primary teaching experience up to class 4 and upper primary not. That's why primary board didn't take into consideration. Here is not the situation. Here is secondary level. These are my humble submissions. I'm taking a loss.
Yes, certainly. Yes, anybody else
In
who
this
would like to
matter
make
only
submission?
Can two, my lord, they have filed.
Your
opposition.
prayer, how have you drafted your prayer?
My lord, I have not challenged the rule because, my lord, I have.
You want the court to,
One thing is, my lord, I have stated and my lord, they make my submission, they have not following their rule itself because there is this separately, they have stated there is the two, another, my lord, the experience separately. That's why, my lord, they are not entitled to marks teaching experience for 9-10 to 11-12. I have not challenged to set aside the rule that is not, my lord. My subject to your lordship correction.
no, but then what your submission is and what you've made out in the writ petition are completely different. You say that what they have, their rules are proper.
Yes,
You
because
say
that's
that their rules are
categorically
proper.
stated, yes.
Then they have acted in accordance with the rules.
No, there is not getting, there is no, there nowhere stated, Malad, the both marks will be given to the 9-10 to 11-12 and 11-12 experience to 9-10. Because they have.
They have stated the rule says even in the 11-12 level, secondary level qualification.
Secondary also, Malad, subject to lots of primary, upper primary also the secondary level.
Then
They
you
are not-
challenge it. You do not challenge.
Malad,
You say you accept.
He did not challenge. The reason is out of 15 petitioners, 1, 2, 3, 4, 5, 6 of them, they are already qualified in
No,
nine.
Clive, before challenging.
I can give the
Malad,
numbers.
they-
That's the reason.
No.
He is the beneficiary of the
Before-
recruitment
no,
process,
before
and out of
publishing the
15,
result,
6
I
of
have
them,
the
they are
recognition.
in the list.
The
That's it.
petition was filed when the results were not published, so he didn't know whether he'll be successful.
In
or
any
not. That's
case,
different.
there are 6 of them are there.
Is not my luggage.
That's different.
No, I'm
But
saying
that time there is
there
no
are
result
6
was
persons. They are already in the list. They took the benefit of it.
Very well.
Yes,
After
that's what I'm saying.
publishing the result, I have not filed the writ petition.
No.
Yes, this I
Yes.
understand, but your prayer and what your submission is are not telling.
Sir, I have stated in my submission, my lord, and in this petition, my lord, only one opposition has been filed.
So what?
Neither state, my lord, we have filed any opposition or school service commission, not.
First, you
neither-
have to make out a case. The case that you are making out and the prayer that you are making, they do not match with each other.
Yes, but
What is to be done?
I have, my lord, the subject to lordship correction, I have, my lord, specific my grounds, my lord, the 9-10 teachers, my lord, they are not eligible for getting the teaching experience mark for, my lord, the 11-12.
The rule says they are entitled to. You have not challenged the rule. Then
I have challenged, my lord, the only conduct of the school service commission, they are not following.
how they are not following, I cannot follow.
Or kindly see page 57, 74, my lord.
Yes, 74.
There is the schedule 2, A and B is written separately.
So what?
So there is no, if, my lord, my submission is that, my lord, if the marks of teaching experience is eligible to all teachers, there is no segregation for 9-10, 11-12. There is the only one clause. Because they are categorically, my lord, stated in the different 2 clauses.
Please come. The petitioners in the instant writ petition participated in the second SLST, 2025. In respect of classes 11 and 12, only 11, 12. Stop. They allege that the commission ought to act strictly in accordance with the West Bengal School Service Commission (bracket open) selection for appointment to the posts of assistant teachers for upper primary level of classes bracket third bracket except work education and physical education bracket close comma classes 9 and 10 and classes 11 and 12 bracket close rules 2025 page 64 রুলের নামটা দেখে নিতে পারবেন stop according to the petitioners comma the commission ought not to award marks on account of prior teaching experience to the candidates who do not candidates who taught in the 9-10 level. না কি দিয়ে শুরু করলাম and do not have experience in teaching in the 11-12 level if they are participating for recruitment at the 11-12 level stage. Stop. The petitioners contend that only teachers dedicatedly appointed in classes 11 and 12 may be considered for providing marks on account of prior teaching experience at the 11-12 stage. Stop. Without actually taking classes in the 11-12 level stage, comma, marks on account of prior teaching experience ought not to be awarded to them. Stop paragraph. The petitioners submit that the recruitment rules specifically lays down different criteria for appointment at the level at classes 9 and 10 and 11 and 12. Stop. The posts for classes 9 and 10 and 11 and 12 are different. Stop. The scale of pay in respect of the teachers for classes 9 and 10 and 11 and 12 are separate. Stop. Same experience cannot be counted twice for providing marks on account of prior teaching experience. Stop paragraph. The petitioners have prayed for issuance of a writ of mandamus, inter alia prayed for issuance of a writ of mandamus commanding / directing the respondent authorities and particularly the commission to publish notification by mentioning special benefits which should be given to candidates who intend to participate in the second SLST by considering their experience in their respective subjects and positions. Stop. The petitioners also pray for a direction upon the authorities to publish notification by granting full marks for lecture demonstration and publish fresh notification by giving clarity that lecture demonstration marks will be granted to the untainted teachers who have worked in connection with SLST 2016. Stop. Next. The several applications were filed in connection with the instant writ petition. Stop. According to the applicants, the the Commission rightly published the rules by mentioning that prior teaching experience marks will be awarded to candidates both in respect of the 9, 10 and 11, 12 classes if the candidate has taught in the senior level, secondary level in a government or government aided or government sponsored school. Stop. The applicants who are opposing the prayer of the petitioners contend that the experience obtained by the candidates in the secondary level can certainly be taken into consideration for awarding marks on account of prior teaching experience for levels 11 and 12. Stop. According to the applicants, the any classes above 9 and 10, above 9, has to be taken as secondary level classes, and the authority has rightly not made any distinction between the secondary, that is 9, 10 level, and higher secondary, that is 11, 12 level. Stop. Prayer has been made to dismiss the writ petition. Stop. Upon hearing the submission made on behalf of the petitioners and on perusal of the prayer as well as the documents annexed to the writ petition, it appears that though the petitioners do not challenge the recruitment rules directly, but indirectly the petitioners pray for a direction upon the Commission to publish further notification by disclosing how marks are to be awarded to the participating candidates. Stop. Paragraph. The submission of the petitioners that the Commission is not acting in terms of their own rules does not appear to have been own rules cannot be properly proved before the court. Stop. According to the recruitment rules, the rules, prior teaching experience in respect of classes 9 and 10 and 11 and 12 will be awarded to candidates provided they have the experience at the secondary level in a government or government aided or government sponsored school. Stop. The recruitment rules does not mention that for the candidates who are contesting for classes 11 and 12 will be provided marks on account of prior teaching experience only if they have got prior teaching experience at the 11 and 12 stage. Stop. The rules clearly specify that marks will be awarded to candidates both at the 9-10 and 11-12 stage if they have got experience at the secondary level. Stop. Next. This submission of the petitioner and the prayer made in the writ petition appear to be contrary to each other. Stop. The writ petition appears to be misconceived and cannot be allowed. Stop. The writ petition fails and is hereby dismissed. All connecting applications stands disposed of.
To judgment I have placed, my lord.
None of your judgments are
For
applicable.
liberty to file app.
No,
No, my lord, kindly.
After this,
no.
deeply obliged.
After consuming such a lot of time, when it is brought to the notice of the court by the applicants who are opposing your prayer,
Kindly answer.
that your prayer is not proper, now you say you want to file afresh.
Kindly.
Sorry, sir. এখানে একটা লাইন একটু লিখে দেবেন তো, affidavit in reply filed on behalf of the petitioners against the affidavit in opposition filed by the applicant in Can 2 of 2025.
That was my opposition.
Be written with the records. One minute. This is item number 37.
31 cause title বলো না।
Bishwajit Bishwas.
মানে মে আই ইন্ডিয়া কি অপোজিশন দিচ্ছ নাকি? কপি দাও।
ঠিক আছে? অন্যগুলো বলছি।
দিয়েছি। তুই দেয়নি।
Yes, please.
হার্ড কপি দাও। হার্ড কপি দাও। But I not got the copy, my lord.
Which matter? All right.
But I not got the copy, my lord. It will be kind enough if
We-
I understand.
All copy will be circulated.
Yeah.
We started off 1 minute. We started off from item 30 today,
Yes, yes.
right? Yes. Item 30, লিখুন একটু।
My submission was in 30 and also in 32 because
30
my
and-
opposition.
All
was
right,
30.
all separate orders are being passed possibly. Item 30 তে একটু লিখে নিন। Had submission made on behalf of the applicants. In Can, yours is Can?
Well, Lordship may kindly, my can was in 32.
30, you are not a party?
30 because Lordship was
Hearing all matters
hearing
together.
that's the reason I said Lordship may use that copies. It would be convenient. But my oppositions that Lordship has seen the earlier occasion, it was from 32 itself.
In 30, are you a party?
No, I'm not a party. 30, Dr. Gurushami mainly referred documents from 30. That is the
Right.
reason I thought that since Lordship might have marked in 30, I should not disturb it.
All right.
But I placed all my
You
documents.
were not there in
No,
30.
no, in 30 I'm.
All right, 30 তে তাহলে লিখো।
I'm for the petition.
But one thing, but there is one thing. There is a can 3 in course they made, so kindly.
In 30?
Because effectively I made submissions, yes, in 30 also. Can 3.
Can 3 is there in the list.
Yes, so that needs to be allowed.
But before that,
That's by,
That is your Can.
yes, yes.
All right, তাহলে heard. Applicants in Can 3 of 2026.
They might have realized later that this,
Because all cans are of 25. This only I see in 26.
yes, and today's list, that is one can is
Only one can is
can there
there.
is not disposed of.
Yes. আচ্ছা, তাহলে একটা order লিখুন যে as any order passed in the instant writ petition may affect the applicant accordingly, may have far-reaching consequences. Accordingly, the application being Can 3/2026 stands allowed. Stop.
deeply obliged.
Let the applicant, one or how many?
কত
You know nothing.
by this application part, Lordship.
Application,
There are 3.
acha, the applicants be formally added as parties in the instant writ petition. ঠিক আছে? It will be in Lubana. Did you file any opposition? It's already there.
Give a copy.
All right. And then who is going to make submission in Lubana? Item 30 now. Who's going to make?
It is my petition, madam.
Yes, but then the respondents are to make submission. Is it in 30? 32.
May I, because of that, madam, 10 marks challenge is there.
Mhm.
In another matter, my lord, another two, my lord, facet I could say, my lord, because of that, my lord, one is that, my lord, in other subject, suppose a person who taught in.
The one that I have dismissed today
That is
was
the rule.
not on merits.
No, my lord. That is rule is not challenged, but in my
Yes.
matter.
So this will not have any
No,
effect
it will
on
be
the
my-
other
my matter.
matters.
So, my lord, it will be kind enough in this bunch, my lord, from item number 30 to 35, that is rule challenge. All matter are rule challenge. This matter is also, it has two facets. One is that, my lord, in other, suppose a person taught in English, got benefit in education subject, secondary education. So that is the challenge in this matter, my lord. Another thing is that, my lord, secondary. No. It is filed earlier.
Not in this bunch.
Not in this bunch, not in the year 20.
There are several matters
Several matters.
which are coming up.
My lord, that is filed earlier, my lord, not in the list, my lord. It will be kind enough tagged with this matter, my lord. Otherwise, my lord, these two facets is, one is that he taught in the English subject, he got benefit in the education subject, which is not permissible, and rule is challenged in this matter, my lord. It will be kind enough, my lord, take up this matter, my lord.
All right, you give the number,
Yes,
it
yes.
will be added in this list. No. Today I have spent the entire second
Second
session on this.
No.
Then how can it be taken up tomorrow?
My lord, then
I'll
item number 36, very near.
1 minute, 1 minute, I'll come.
Yes.
30, when do I keep it? The AG was here.
But there is now not that much of urgency because
Time
now
has.
time has been. That's what I'm
Yes.
saying.
এই মেটা কিছু 13 তারিখও আছে 13 তারিখে থাকলে 8 তারিখেও আছে এই সপ্তাহে তো রাজ্য
The next week.
এখন তো এসেছে
Some matters were fixed next
On
week.
13th.
Also, my lord, your lordship has fixed that,
No,
after third
8th
council-
is just. So let us all have some
Yeah,
time.
yes, some breathing time should
On
be given.
Lordship may
Because
keep,
every day new points are coming up.
yes, Lordship may keep it all the matters on 13th
So 13th
or
is all-
any other subsequent.
Matter that is expiry panel matter is already fixed.
Then I'll not fix it on 13th. Rule will be the later on. 20th of January.
Yes.
List 20th of January. 31, give. Yes, Shishir Dash. Affidavit in opposition, item 31. By the commission, filed in court today, is taken on record. Stop, let copy of the same be circulated. Released,
My lord, in third,
ওই একই দিনে, 20 তারিখে। 20th.
in 32, I already filed my opposition and this was taken on record
Earlier,
earlier.
yes.
So,
So only one line order, list on 30th.
yes.
30th, na 20th. All right. I was calling for advocates to make submission. At least let your juniors come prepared to this little bit of extent so that the court can proceed and the senior can come and take up. So they also get a chance to learn and you also get a chance to move around in different courts.
Yes, that I was expecting that.
Why are you
He is more worried about.
skip track? Acha, 33 list on 20th of January. Nothing filed in 33 today?
Not today, it was already filed.
34 Choitali Mukherjee, anybody filing anything in item 34? No.
The petitioner, my lord,
Tale list on ওই তারিখে. And 35?
nothing in.
Nothing. All right, then
For the petitioner.
are you over with your oppositions in these matters?
Yes.
In 35 minutes, we'll have to file.
There.
The,
36, in 36.
Speak here.
My lord, 36, my lord, I will make, because of that, my lord's first order, 19 September order, 19 November, pardon me, 19 November order, Supreme Court specifically stated about this matter, my lord. My lord passed the order on 19th November, my lord. But till date, they have not published that list, my lord. Why, my lord? I just, my lord,
But then
para
one
30
of the orders have been kept, directed to be kept
No,
in
that
abeyance.
that is another matter. That
That
is
is
Subit
separate.
Shokar, my lord. That is not. But here, this matter, my lord, my lord, kindly take up this matter. I will not.
I'll take it up tomorrow or
My lord, kindly
any.
keep it tomorrow because of that, my lord. 19 November order not yet carried out. My
All
lord.
right.
Mousumi Mondol. Mousumi Mondol. Para 35.
No, no.
No, my lord. Mousumi Mondol is not a
35.
challenge.
Till 35, it is on the 20th. Moushumi Mondol is 36. This
Different matter. This is different matter. There is.
remain in the list.
Yes, my lord.
As it
Because
is.
of that, my lord, there are several facets, my lord. I will place.
আচ্ছা আজকে যে স্লিপটা দিল ওটাকে রুল চ্যালেঞ্জ এই 35 এর যে বান্ডেলটা রয়েছে 30 থেকে 35 ওর সাথে দিয়ে দেবেন,
Yes.
উইথ করে দিয়ে দেবেন।
Because of.
All right. 36 onwards tomorrow. You give your appearance. Yes. 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 I'll hear everybody. Nobody will be shut out from here because that will be a good ground to challenge.
Thirty-six is mine.
Lordship, before your lordship rises, my lord, the 415 fix matter.
Yes.
My lord,
Round the 415 fixed matter. The state and everybody who are there. So
My lord.
if the requirement of the police is required, I do not know, then they may be there.
No, my lord, I will tell your lordship about the present situation. No police help, nothing is required. Only,
What is
my
the
lord,
money?
only, my lord, the execution case going on because he has instituted so many cases against the judicial officers. The learned JM is not executing the arrear amount. That is all. And, my lord, I have prayed for attachment of his salary account. I have shown your lordship that order that he is intentionally not giving this order and telling that he is not getting the money, but it is there.
Come tomorrow.
That
let's-
petition is not being disposed of by the learned JM. my lord.
All right.
Grateful.